Good morning and welcome to the first DCA. We have two arguments on our calendar this morning. We'll take them in the order in which they are noticed. The first case number 24-2352, Tri-City Electrical Contractors versus Robert Gondek. Ms. Sills, when you're ready.
May it please the court, Eleanor Sills on behalf of Tri-City Electrical Contractors and Amerisure, the EC in this case. I would like to reserve 5 minutes for rebuttal.
Noted, thanks.
I would like to start with issue 2 in this case. I have a lot of ground to cover this morning, and so I would like to go ahead and jump into something that's a little less factually intensive. So as for issue 2, the JCC erred when he awarded attendant care because Dr. Shea's IME report was not a prescription. In addition, there are two other problems with the award of attendant care, but the first is dispositive as to whether the attendant care should even be awarded.
Does it make a difference that the potential the IME wasn't even authorized since there wasn't a dispute before the IME was hired, I guess?
Your Honor, I don't think it necessarily makes a difference in regards to whether it's a prescription, but I think that that is something that certainly plays into this case. Do you know what
I mean, is the way I read the record, and correct me if I'm wrong, the dispute was actually the claimant's dispute with his authorized doctor and his failure to prescribe attendant care. So he went to get an IME, I guess like a second opinion, and I don't see that authorized in the statute.
Your Honor, and I think that that's correct. Dr. Ramirez is the doctor who said if I was to prescribe attendant care, I would have, and that just I didn't find it necessary at the time. And that was September of 2022, right. And Dr. Shea did his IME report in 2023. So I would say the dispute was also a bit later, if there was a dispute at all.
But then at the same time, could any doctor prescribe attendant care, or does it have to be an authorized physician?
Your Honor, I think the context in this court's case law specifically speaks to that an IME doctor cannot be medical treatment. And if you look at the statute, it requires the attendant care to be awarded at the discretion and control of a physician. If an IME doctor is only seeing the claimant once, I don't see how it can be in the direction and control of that IME doctor.
Sure, but imagine, like, instead of calling it an IME, let's say he didn't like his authorized physician and what he had to say, so he goes and freelances and gets his own doctor. Not calling an IME, just gets another doctor, and that doctor looks at him and says, and prescribes, if you want to call it that, prescribes attendant care. Would that have been good enough? Or does it have to be an authorized physician, authorized by the carrier, the servicing agent?
I would say that it needed to be an authorized caregiver in that regard. I don't think that we can doctor shop.
But the direction and control would exist there. If you go out and find a doctor and the doctor prescribes it and you're the patient of that doctor, then Sure. It seems like you have that element, which is an element here that seems like it might not be there.
And I think that would be fair, and I think that the facts of this case do present a different scenario as we're discussing this morning.
What guides should guide our interpretation of what the statutory reference to a written prescription should mean? Well, what is a prescription, and
Sure.
What does that look like? Is it standard, or can it be anything that's written down?
I don't think it could be anything that's written down, and I think that it's interesting that we see in the record there are these forms that would be written on by an authorized treating doctor, and you can check attendant care, and I think it's I can't remember the name of the form, but it's in the record, and this was actually in response to a question within Dr. Shea's IME report, and so I think that is also makes it different than what a prescription might look like. And so I would submit that that's just not the same as what a prescription typically is, and I think that we look at the statutory text, we look at the context, and of course looking at this court's case law as to whether an IME is even a treater, I think that that also plays into it, and we can look at dictionary definitions, sure, but we also need to look at the context as a whole. And
would it be fair to look at Chapter 465, which deals with regulation of pharmacies, and not surprisingly in the regulation of pharmacies there's a pretty detailed definition of prescription that would seem to support your argument. Would that be a fair thing to look at in trying to discern what the legislature meant for prescription in 440?
Absolutely, Your Honor. I think that is also taking into context statutory provisions that would play in this regard. So on the attendant care, I think that that's dispositive of the whole entire issue. And again, I just think that the definition of an IME doctor who is supposed to be an independent evaluator, while maybe that's not always the case, or maybe we have competing IMEs, that again is, different here. And I think that the text and the context show that a prescription, or Dr. Shea's IME report in this case was not a prescription. Now, there are two other problems that I just want to briefly address, should this court disagree and find that it is a prescription. The retroactive award of the $12 an hour award that was given to Mrs. Gondek went back to March of 2020. And I think, again, the text of the statute shows that you can't prescribe retroactive attendant care, but I also think that because the EC is not responsible for the care until the prescription is actually presented, and here the JCC awarded attendant care from January 3rd, 2024, continuing, we should not take a snapshot in time of 3.5 years back as to what the non-skilled caregiver, or the family member in this case, Mrs. Gondek, would be making at the time. And I think that the JCC erred and by retroactively looking back in that regard. And in addition, the award, failed to meet the statutory requirements of the quantity, quality, and duration of the care, because that's just not specified at all, not only in Dr. Shea's IME report, but also the JCC's final compensation award. Now, turning to issue 1, which is the misrepresentation defense, the JCC erred because he failed to recognize that Mr. Gondek made misrepresentations, and then he instead looked at a subjective component of the testimony that was given. And he looked at, instead of first looking at that first objective evaluation, under Cal-Maine, this court's case, it's a two-pronged test. And the first prong I would submit to this court is an objective evaluation of if there was a misrepresentation. The second prong is a subjective evaluation as to whether there was the requisite intent under the statute.
The hypertension claim might seem to be relevant in the alleged misrepresentation on that. The ED meds and the anxiety, though, since there wasn't a claim for that, why does that have any materiality here such that it would be a misrepresentation?
Yes, Your Honor. Under this court's case law, specifically citrus pest control, a claimant's relevant medical history is important here, right? And that's especially true where he was treating with a psychologist, Dr. Cubano, so his anxiety, and Dr. Cubano actually specifically opined that because there were no prior, incidences of depression or anxiety or things like that, he included that in his analysis. So I think the anxiety plays into that. As for the erectile dysfunction medication, now Dr. Shea is recommending significant intervention for that for Mr. Gondek, and I think that plays in. But I think under this court's case law, regardless, a prior accurate medical history is important, and that's citrus pest control for this court. So, as I said, there's the two-pronged test under 440-105. I believe that the first one is an objective and evaluation, and the JCC here erred because he played into the subjective intent prong into the first prong of this analysis. And so I'll take them in turn. We have 3 different areas. First, the hypertension. Mr. Gondek testified that he was not diagnosed with hypertension and that he was only taking medication for about a month-ish, quote, before the accident. Well, that's contradicted by evidence in the record, blatant evidence in the record. There's pharmacy records, there's diagnoses, there's testimony from his treating doctor, all that he was diagnosed with hypertension, as well as that he was taking this medication, lisinopril, losartan, things like that, as early as 2014. And now, the JCC specifically determined that because the claimant testified that he was taking Adderall, which is not corroborated by any medical evidence in the record, that his subjective belief that he did not have these diagnoses was, I guess, a substitute for the fact that he did not make a misrepresentation. But that doesn't explain that he was taking the medication, why he testified that he only was taking it for a month-ish before the accident. That maybe plays into the subjective intent for the purposes of the misrepresentation made as to the diagnosis. It doesn't play into why he was taking this medicine from 2014 on, and that it's throughout his medical records and his pharmacy records. I mean, it's all throughout this record.
Didn't the carrier have access to all that information? I mean, this claim they've been processing this claim since, 2017?
Sure, so the misrepresentations didn't occur until his deposition. That was later.
Right. So, I mean, but the employer and the carrier, or the servicing agent, whoever's processing the adjuster, has access in a lot of these medical records, probably didn't the adjuster have access to all that most of that information previously, was aware one way or the other of what his treatment plan was or what his history was?
Your Honor, it's my understanding that it was difficult to obtain these records, and I actually think they only go back to 2014 because the PCP was unable to get, or they changed their programming or something like that where they couldn't get it as far back, and I believe that there was a dispute as to whether the records were able to be subpoenaed or received. So I'm not sure how long the carrier, and I don't think the record necessarily reflects how long the carrier actually had the records in their possession, but I think that there's inconsistencies in what Mr. Gondek was reporting to his doctors throughout this, throughout the life of the claim.
440, 105, 4B, dealing with misrepresentation, unlawful for a person to, and then a variety of things, but all of them seem to have knowingly in front of them. So when the JCC finds that any misrepresentation or any false statement that the claimant made was not knowing, isn't that, CSE for the finding such that we can't touch that?
Your Honor, I don't think it's CSE here because I think that the JCC1 failed to even recognize that there was a misrepresentation. And so I think that the JCC did not necessarily get to the intent analysis for a lot of these misrepresentations. And I think this is illustrated by the fact that maybe there, if this court were to construe the self-serving testimony of Mr. Gondek.
All testimony, if I'm a plaintiff in a case, my testimony is going to be self-serving. I'm not going to typically put on the defense case, right? So,
sure.
Yeah, and you'll make that argument, but that doesn't seem like your strongest argument there, that it's self-serving. It's still CSE if the JCC believes it, right?
I understand. Yes, Your Honor, I can understand that, but I don't think that that he did not think he was diagnosed with hypertension or erectile dysfunction explains why he testified that he was only taking this medicine a month-ish before the accident for the hypertension, and as the JCC found, there was a misrepresentation in regards to the medicine being taken for the erectile dysfunction. But I also think that at times, while the JCC's credibility determinations are typically gospel in a sense, there's still times that there has to be constraints on that. And I think that this record shows that simply because Mr. Gondek believed that he had these as a side effect of Adderall, which he never complained of to his PCP, or at least that's not reflected in the medical records, that in and of itself, that the statement alone of his self-serving testimony is not CSE, because it has to be supported, as a reasonable inference. And the reasonable inference here is, I think that it's a strained interpretation to reach that.
Is the statute designed to, this sounds more like a discovery sanction, almost like if it were in a civil litigation context. Okay, the plaintiff gets caught in a lie or some sort of misrepresentation during deposition, then you put them on the stand during the trial, and that's impeachment evidence. It just seems odd to then have this develop within discovery in the case to give rise to an affirmative defense, which is almost extrinsic or intrinsic to the case as opposed to something that happened previously or in connection with the actual claim. Or to put it differently, the statute seems to read more to get at employees that, let's say, they don't tell the truth about the facts of the injury or the facts of the accident, and that's misleading to get compensation. Okay, now that's an affirmative defense. Here, it seems like the employer is trying to play, after processing the claim, accepting it for quite a while, does a deposition and almost plays gotcha to get out of the claim. Is that what the statute is for? Is to provide a remedy for, being misleading during a deposition, for instance?
Your Honor, I think that was a policy decision that the legislature made to say even a misrepresentation can lead to this. And so I think that, yes, that this is something that the statute is geared towards. And I understand that maybe it feels unfair, but that's the legislature's decision to do that. And we're stuck with what the legislature said in that regard.
On both the obesity and the hypertension, there's evidence that even if he had that pre-existing, it got substantially worse. Like a whole lot more weight, 180 over something for blood pressure, terrible high blood pressure. So even if he had that pre-existing, how would that be material when there seems to be record evidence to support that he's got a need for treatment for both of those conditions?
I think that it's material because he's seeking to continue to maintain these benefits that he's receiving, and by telling his doctors things that are not true in regards to the previous or pre-existing conditions. And I also think that there's, and this kind of plays into the third issue in the briefing, that there's no evidence about MCC. I think that there's nothing in the record that says this is more than 51%, the accident was more than 51% of the cause of the need for additional medication, weight loss, the hypertension, all of things like that. I certainly agree with Your Honor that, yes, it's reflected in the record that he gained a lot of weight and that there was higher blood pressure readings. I don't disagree with that.
Didn't Dr. Shea seem to say that that's what led to the need for the GLP-1?
And Dr. Shea, I agree that Dr. Shea did say that, but I think that there's that alone, that medical testimony is not necessarily saying that it's more than 51% of the cause. I think that that's almost the magic language in this regard. And I see I'm into my rebuttal time if the court has no more questions.
Thank you. Weiner.
Good morning again, Your Honors. May it please the court, Mike Weiner here on behalf of the appellee claimant, Mr. Gondek. Your Honors, we are here asking you to affirm the opinion or order of the judge of compensation claims for several reasons. Number one, because it was the judge's job to conduct a final hearing, to receive the evidence, to review that evidence, and then to evaluate the credibility and candor and demeanor of witnesses, and most importantly, to make the ultimate resolution of intent, which is exactly what he did, and he did it properly here. Number two, because the carrier bore the burden of proof on their affirmative defense of fraud, and they simply failed to meet it. We need to dispossess ourselves of the notion that the appellants put forward in their brief that the claimant needed to prove this or needed to prove that. He didn't need to prove anything with regard to the carrier's misrepresentation defense. He could sit there silently and do nothing and just let the carrier not prove it, which is frankly what happened. But he did provide evidence. And even despite that, and comes from the Mitchell Communications case, that the decision in favor of a party without the burden of proof need not be supported by competent substantial evidence. But the claimant still did come forth with evidence that was competent and substantial that supported the fact that he did not knowingly, and I think Judge Bilber, you made a very important point here, that those false statements have to be knowingly made, and I think the carrier glosses over this in their briefs. They just say any false statement. Well, that doesn't tell the whole story. They cite to the Howard case for saying any false statement, but a false statement has to be knowingly made, and then it has to be made with the requisite subjective intent, which the carrier must prove that he did it because he wanted to get a workers' comp benefit or because he thought it would have a material impact on his case. And the judge looked at the credibility. He did what this court cannot do, right? He looked at the claimants into his eyes. He listened to the inflections in his voice. He looked at his gestures. Was he covering his mouth? Was he fidgeting? Was he sweating? All these things. None of these things this court, as a reviewing court, has the opportunity to do.
Is there at some point where a JCC doesn't recognize that there are manifest untruths that are given that should tip into our analysis of of the knowing part?
What the claimant knew is a subjective inquiry that has to be determined by the judge of compensation claims, right? This court, I would submit to you, as a reviewing court, and I pointed this out, I think, in our notice of supplemental authority in the Wall, referencing the Wall case, which I wish I would have put it in my brief and I overlooked it, but I think it pretty much is the penultimate exposition of what is the role of the JCC versus what is the role of this court, right? Especially when it comes to live witness testimony in front of the JCC, which we had that here from the claimant and from the claimant's wife, which the judge evaluated. And then he also looks at it and says, well, how does this all square up with all this surveillance video that I'm seeing? Right? The carrier had hours and hours of surveillance video. And so the judge takes all this in. He resolves all of these conflicts, which is what his role and his duty is. And then he makes the requisite findings of intent. And what this court said in Wall was that under our deferential standard of review, we make a legal assessment as to whether someone reasonably could reach the conclusion that the JCC reached about a certain facts when faced with the evidence submitted, right? And I would humbly submit to you.
So whether a JCC mischaracterized objectively something as an untruth, a half-truth, or, misleading or something like that, that other side of the equation sort of stands on its own.
Well, I would say some things can be black and white, right? Certainly. But when we are attempting to pervade into the claimant's subjective intent of what he knew, and whether what he knew he was consciously misrepresenting in an effort to secure some form of workers' compensation benefit, that exclusively belongs to the JCC, right? We don't, and that's what we have here. We don't have a sort of a black and white issue. And I really would take issue with some of the statements. I don't feel as if some of the statements I heard today and some of the statements that are contained in the brief are really a fair and accurate representation of really what is contained in the record. We heard today that the claimant repeatedly denied that he had that he had ever taken any hypertension medication up until a month before his accident. That's not true at all. He was asked about this. He admitted to taking hypertension medication through Gretchen. That's at page 1595 of the record. He then admitted that he took hypertension medication since 2013 that was prescribed by Gretchen, and he apologized for his confusion as to the dates because, as he said it, my memory is bad. Okay, that's at page 1599 of the record. So the claimant fully disclosed in his deposition that what the appellants have done is try to take certain things out of context here, right?
Well, but that's I was asking your opposing counsel this question. That's why this whole posture doesn't make sense to me. Like when I read 440.09.4a, it talks about not being entitled to compensation or benefits if any JCC or ALJ, court or jury determines, that the employee knowingly or intentionally engaged in any of the acts described. So why would jury be mentioned in that? Why would a court be mentioned in that statute unless it is cross-referencing some extrinsic events? And then, if there's a determination that something that the employee did wrong outside the case, then that could be a basis for terminating benefits. But to go through this process, they file a PFB, and then there's a deposition taken, and then it's like, aha, we got your client, because he said one thing here, and then he says another thing on the stand, or he says one thing in depo, but now we have the medical records, and we've caught him. And so now we have an affirmative defense, and to heck with all the other things we were going to assert, now we've got the brass ring, or the golden ticket on this. That doesn't strike me as the way the statute's supposed to be.
Well, I would agree with your interpretation of it, Your Honor. I would hazard a guess that the reference to jury is because sometimes this issue can be brought forth in a criminal setting, and that's probably why the
That's
legislature.
exactly right. Or in a civil case,
Right, or in a civil case,
civil
right.
case where the person's been found to be
And I
violent.
think there's sort of a gotcha attempt that's being used here, both in terms of legislatively trying to game the system as part of what the appellants have done here, as well as in terms of a lot of their statements lacking context, right? If you say one thing here, but you later clarify or explain it later, right, that doesn't mean that this thing that you said here that you can only hang on to A as a basis for misrepresentation. We have, in this case, is in every case, and this is a 3,000-page record, right? Of course we're going to have conflicting evidence. Of course there are going to be things that, conflicts the judge will have to resolve. And then we've got a gentleman here who, let's look at the claimant, right? Tragically injured. Dr. Shea calls him among the worst injured of any, the highest level of injury you could possibly have. He's got autism. He's got ADHD. Now he's got all these other issues going on. He's got these urinary issues. He's incontinent in his bowel, and he defecates himself. He's had a back surgery. He's got, had a spinal cord stimulator. He subsequently is diagnosed with complex regional pain syndrome. He's seen all these litany of different doctors. And so is he going to maybe make a mistake about who he saw or when he took something? Yes.
6 or 7 years earlier.
Especially all those years ago, right? And that's why context matters so much. And that's why the judge has the right to look at him and say, man, I can understand how he might get this wrong, given all that he's been through, and not be knowingly lying about it, or not knowingly lying about it for the purpose of securing a workers' comp benefit, which is exactly what the judge of compensation claims did in this case, right? He resolved those issues as to intent.
Can I jump you ahead to the second issue
Yes.
that they've raised on the prescription? I had cited a minute ago, Chapter 465 on the pharmacy chapter, which has a detailed definition of prescription, which is what we would typically think of a prescription. You go to the doctor and, okay, you got high blood pressure, here's your prescription, go get, whatever meds to treat that. Why is that not the appropriate definition of prescription for us to use, as opposed to saying an IME equals a prescription?
Yeah, it's a good question, Your Honor, and I'm glad that you asked it, and I was hoping to get to it. If the legislature wanted to confine the definition of prescription to as it is in Chapter 651, or give it some other definition, they could have done so. They didn't do that in the context of workers' compensation. I would submit to you that a prescription should be given its ordinary, plain language, dictionary definition, right? What is a prescription? It's something in writing that makes a recommendation for a certain type of care, okay? What the carrier has done here is they're exalting form over substance. They're trying to say that because, and by the way, the most nefarious part of their argument is that what they're saying is that an IME doctor cannot recommend attendant care because he can't prescribe a prescription for it because he's not a treating doctor. We agree, an IME doctor is not a treating doctor. But to
And they're brought into a case for a specific purpose, to write up a report, to evaluate and write up a report. They're not there to treat, or I doubt this IME took on Mr. Gondik as a patient. So the direction and control, it's all sort of wraps in there together, that this is it seems to be a very limited scope function of what an IME is serving here.
Precisely. An IME does an independent assessment, and then he makes recommendations. The statute seems very clear that an IME doctor cannot provide treatment unless the parties so agree, right? Not an issue here. You did reference Judge
Yeah,
Tannenbaum, and I
was
want to
gonna
get
ask,
to.
but an IME is also not authorized unless there's a dispute over, one of the listed things. So where's the dispute here?
You beat me to it. Okay, so this was not briefed by the parties, and if I get the case name wrong, I apologize. I believe it's Cortina. In the Cortina case, discussed the issues where you can arise to a dispute. One of the basis upon which a dispute can be created if the claimant goes to an authorized treating doctor, receives a diagnosis or recommendations for treatment, and he disagrees with that, the claimant is saying, I disagree with that. That is a dispute. That is a dispute that lets the claimant get an IME. So in this case, the claimant...
How is that a dispute regarding medical benefits under this chapter?
This is what your honors have said
Well, I know,
in the
but I'm just looking-
Cortina.
I'm making the
Well,
mistake of looking at the
yeah,
statute.
I guess the easiest way to say is that, at some point, Mr. Gondek and his wife said, you know what, we don't agree with the fact that no one has looked at this attendant care issue, right? None of these treating doctors have looked at it. And so we disagree with the refusal of the doctors to address the issue of attendant care. I think I need more than what these doctors are recommending. Ergo, a dispute exists, right? The dispute is a really low threshold.
But the
And I would say-
doctor's not recommending something. It's an authorized provider that's treating your client.
Right.
It's not, they're providing treatment. They're
Right,
not
but-
operating within the context of a disputed claim. They're just providing treatment.
They're
And your
provi-
client didn't like what the provider, the course of treatment. Why not seek a one-time change instead?
Well, that would be another way that you could go about doing it.
Well, it's statutorily provided for.
It's
that
allowed
is an
for, but
avenue.
it doesn't mean that
But
you
not the
can't.
IME.
But it doesn't mean that you can't get an IME for that, right? Because all you have to have is a dispute. A dispute is nothing more than a disagreement. So when the claimant shows up at Dr. Rodriguez's office, I think was the last physician who saw him, and he says, you're good to go, I got nothing else for you. The claimant's free to say, I disagree with that. I have a dispute as to that. And the statute says, and has always said, and it's always been interpreted that way by this court, that you can get an IME to resolve that dispute. You don't have to have...
Between the claimant and his physician?
Yeah, that's the way it's been interpreted in the Cortina case. And again, listen, candidly, neither of the parties have briefed this, so I'm
And then is
kind of
the JCC
extemporaneously
supposed to
speaking
come-
on this matter.
Is the
so-
JCC supposed to come in and then resolve the dispute between the physician and the IME?
Yes, sir.
Is the employer party to this, or do you just bring in the IME? Who is the respondent in that petition?
Well, the carrier did in fact respond to it, and they contested it, and they got their own IME to dispute the dispute that had been created. And this is the way the system has always worked, and I would submit to you that it was designed to work, right? Because the carrier gets to control everything, right? They get to pick all the authorized treating doctors who the claimant will get to see throughout the life of the claim. The claimant has really very little by way of agency in his case. He can ask for a one-time change, but as this court is well aware, if the carrier responds in 5 days, they're going to pick somebody else he gets to see. So the claimant has to have some sort of an out that when he says, okay, I really don't like the doctors the opinions of the doctors that you gave me. I don't agree with their opinions. That creates a dispute. The dispute gives rise to the entitlement to an IME.
I just don't see how that's an opinion. When the doctor is treating your client and comes up with a course of treatment, which has been authorized by the carrier, and the statute allows, if you don't like what that physician is doing, you can seek a change. This seems to circumvent that whole process and allow you a second bite.
That's always the way that the IME provision under section
but then here we are. So
440.13
now
has
you
been
have
interpreted.
But here we are now. Now you have an IME that's not, that is doing a report, and then that counts as a prescription.
Of course it does, because it
It
is
just
a
seems
written
very-
recommendation for treatment.
Assuming we agree with you on this unpreserved issue on the IME, the IME doctor can't treat, so why can he prescribe?
Well, again, I would tell you that we cannot exalt form over substance, and that when we are to interpret the provisions of Chapter 440, we have a direct legislative intent as to how we are to interpret them, right? And that is to furnish benefits to the injured worker in an efficient manner, right? And so closing the courthouse doors to injured workers who have a medical necessity by virtue of the judge's determination on their merits to attendant care is not honoring that legislative mandate, not at all.
I mean, I assume that if we had some case somewhere where we said IME equals prescribed, that you would have provided that, right? So you're not aware of any cases out there?
I don't think this issue that the carrier has raised in this case has ever been raised before. I certainly haven't seen it. Quite frankly, I find it a tenuous reading at the statute, to put it kindly.
Well, who is the physician that's providing the direction and control over this attendant care? Who is that?
Well, it was Dr. Shea who ordered what was reasonable and medically necessary, and who
Is there
provided a
follow-up
recommendation
appointment?
for care.
There's not treatment here, or there's no follow-up. I mean, where does the direction and control, address direction and control for me? What does that mean?
Well, first of all,
I get the written prescription part. That's a separate part of the statute.
yes.
Direction and control, where does that come from?
I would submit that at this point, it would be incumbent upon the carrier, given the judge's finding that attendant care is medically necessary, to then authorize a treating provider who
So
can
it
continue to
becomes-
provide that.
So direction and control is a future thing.
Yeah. I mean, look, I cannot escape from the unassailable fact that an IME cannot provide treatment. That's what the statute says. But by the same token, the statute has to be read in context with the whole text, right? And the whole text canon is important here. Why? Because section 440.13 subparagraph 5 tells us that an IME opinion is admissible in any dispute, right? The legislature didn't give a carve-out for attendant care, right? This court has held in prior cases that even in EMA, look, an expert medical advisor, right, is not providing direction and control, but an expert medical advisor can be called upon by the judge of compensation claims to provide the ultimate answer as to whether or not a claimant should receive attendant care or not, right?
So that gets back to, I mean, I know it wasn't directly argued, but you can't get away from what I think is the misuse of the IME. The dispute that you're talking about, that you just mentioned as being admissible, is a dispute between the authorized physician and the IME that you sought, not a dispute with the authorized physician and the carrier. And so it still doesn't make any sense. But are you also able to address the weight weight gain?
Yeah, I mean, look, I think this is a pure competent substantial evidence issue. I've cited the evidence in our brief in the statement of facts. Claimant was, and I'm just going to use ballpark numbers here, 270 pounds before. He balloons up to about 330 pounds after. Dr. Shea testifies that is a direct result of his having, been inactive, unable to move, unable to work, unable to function, right? He testifies that the Mounjaro or the GLP-1s are reasonable and medically necessary, and that the work injury is the major contributing cause for all of his recommendations. So again, I take issue with the carrier's assertion that there's no evidence as to major contributing cause. I think that's complete nonsense. Dr. Shea was very clear in his deposition that the injury was the major contributing cause for the weight loss, for the need for the attendant care, and for everything else that he had prescribed.
Wasn't he, he was obese.
That's okay, and that's okay, right?
Before the accident?
You could be obese before, and you could still need it as a result of the accident, especially given the context of, the significant limitations that his injury places upon him, as well as the fact that he had significant additional weight gain beyond that. Now, there could be an argument at some point that the carrier got him back to baseline, and that's all they were supposed to do, but that's really an argument for a different day. Your Honors, we're here asking you to affirm the decision of the judge of compensation claims in all respects. It was supported by competent substantial evidence. Insofar as the misrepresentation defense is concerned, the judge did his duty of resolving the conflicts in the evidence and making, as this court has held as his responsibility over and over again, the requisite findings of intent. He did not find that the claimant intended to make any false statements knowingly, and also for the purpose of securing workers' compensation benefits. And your role as the appellate court, as outlined in the Wall case, is to affirm that decision, because that decision is one which reasonable persons could come to that same conclusion. And we thank you for your time.
Thank you, Mr. Weiner.
Your Honors, I've heard a lot of allegations this morning about nefarious intent or misrepresenting things in the briefs and things like that, and I would just encourage the court to look at the record sites that are in the brief. And specifically on page 1596 of the record, which is Mr. Gondek's deposition, he says, it's asked, how long were you taking medication for high blood pressure or hypertension before the accident? He says, I want to say probably a month-ish. And then later it's asked, so it was shortly before the accident you were taking this medicine? He says, I would say yes. Okay, that is what is in the record, that is what it is, and I would just say that the record speaks for itself in that regard. Now, in regards to the misrepresentation, actually, the breaking down the two prongs, I think that the first prong is an objective prong, and it's a determination for the JCC to look at the records and say, well, was there a misrepresentation here? And I think that comports with the text of the statute, and I think that comports with the legislature's intent behind this statute. And now, Judge Tannenbaum, to your question about impeachment and the ability to use this later on, again, I think that the legislature made a decision to say that it's an oral or written statement, and when that happens, that's when the domino effect comes in. And I think that the legislature chose to do that, and they chose to use those words, and this court has interpreted as much that it has to be a specific statement. And I think that, or oral or written statement, or cause someone to have it, all the statutory text in there.
I mean, what the legislature said was, if a JCC determines that there, it fits within one of the provisions of 44105, then there's no entitlement to benefits. And then we have a situation here where the JCC didn't determine that. And that's why, I asked the question earlier that it doesn't make sense that this would be an affirmative defense, as opposed to if something happened within the proceeding and the JCC happened to determine that there was some misleading statement along the way, that would give rise to a basis, then the employer could say, okay, we're yanking benefits now. But to use the statute as a got you, as almost like a discovery sanction, which seems to be what it's being used as here, is he made what you consider or what your client considers to be misrepresentation in the deposition, and now that gives rise to an affirmative defense. And I just don't understand how that works under the statute.
And unfortunately, I don't think we can write things into the statutes or rewrite them in a way that would be more helpful in that regard. And I know that sometimes that might be tempting, but the court is not supposed to do that in this case. And I also want to address one more thing in regards to the dispute about the prescription. Mrs. Gondek testified that they never asked the doctors about attendant care. So how can there be a dispute if they were never asked about that specific need for attendant care? In addition, I just want to make sure that the court understands there's no argument about admissibility in regards to the IME doctors. That was never briefed, that was never brought up in our brief. That was something that the other side brought up in their answer brief, and there was no argument about that admissibility. It's an argument about the text, context, in this court's case law of interpreting that section. And if your honors have no further questions.
Well, what about the CSE for weight? Obviously they, or the claimant asserts that, well, even though, yeah, he was obese before, but that doesn't necessarily mean that he's not entitled to weight loss treatment now. That sounds like an evidentiary dispute at that point, which we can't really resolve.
I would just say that there's no competent substantial evidence to support the actual determination that there was a 51% or more, the accident was the 51% or more cause of the need for the weight loss medication, especially when he was being recommended for weight loss for years before the accident.
Right, but that's burdens of proof and weighing the evidence is a fact finder's responsibility. That we can't sit here necessarily and look at the record and start making those calculations. I don't know, was it 50, but I know that MCC that's a separate definition, but how do we assess on the record whether there's actually enough evidence? If you have a health provider that's saying that it was, that this is all related to the original accident, the JCC made a determination, you're saying that none of that counts because it's so obvious that he was obese before, so we should just ignore all the evidence that the JCC was looking at and just go with.
No, Your Honor, I don't think you should ignore evidence, and I understand this court is not a court that reweighs evidence, and that's not the point here. The point here is that there's not that specific testimony about that cause, the causal relationship, and I don't read Dr. Shea's report or his opinions as doing that. Thank you, Your Honors.
Thank you, Ms. Sills. Thanks, both of you.